Hello and welcome to this webinar entitled UK GDPR Update, Key Legal Developments and Compliance Priorities with me, Keith Marker. As always, let's begin by having a look at the agenda for this session today. So we'll begin with an overview of the key changes introduced by the Data Use and Access Act. The time of recording of this session, they're almost all in place now. There are one or two that remain to come into force, which I'll be commenting on, but essentially we'll be focusing on the changes that particular legislation makes to the UK GDPR, the Data Protection Act 2018, and the Privacy and Electronic Communications Regulations 2003. So a number of interesting developments there for us to think about. And one of those key developments, which I've sort of separated out as a topic in its own right, is the requirement for a new complaints procedure that specifically relates to data protection. Now, we'll go through obviously the detail of this, but this is not yet in force. This will come into force on the 19th of June 2026 even. And at that particular point, you will be required to have certain procedures in place. Now, it's not actually quite as bad or as onerous as it sounds, but we will be going through what the guidance is on this and what you need to have put in place by that particular date. Then we will talk about the leading case we now have on subject access requests under the UK GDPR. The case is Ashley and HMRC. So that's Mike Ashley of Sports Direct fame, and well, the HMRC need no introduction, do they? And they sort of slugged it out in the High Court for a while in terms of some of the key questions to do with subject access requests, such as what is the definition of personal data? Also, what does it mean to carry out a reasonable and proportionate search? And finally, how information should be provided in practice to the data subject. So we've got some guidance on all of those things from this 2025 case of Ashley and HMRC. We're then going to talk about compensation claims. Now, there have been a whole load of cases on this, and in fact, you can find a whole hour on this topic that I've recorded for MBL. However, we're going to focus our attention on the most recent case that's been decided. It's called Farley and Paymaster, which very much seems to set the cat among the pigeons, shall we say, in terms of this sort of claim. So there are various sort of limits on these historically that we've had that to some extent the Farley and Paymaster claim actually strips away. So I'll be looking at what those changes are there. And finally, we'll look at briefly at one or two examples of regulatory action, just to get a flavour in terms of priorities of the regulator with regard to enforcing data protection, which seem to be shifting slightly, as I'll illustrate at the end of today's session.